Well, thank you so much for inviting me over. I'm very lucky to be here, so it's great to have this opportunity to talk to you. So what I want to do in this talk is try and introduce you to some of the madness of the post-Brexit constitution in the UK. And I want to think about what this means about a particular theory of constitutional analysis, which I work on, which is dialogue. So for those of you who are sort of not familiar with dialogue theories, these are theories that try and think about how in constitutions we should encourage some kind of interactions between different institutions. So the idea is that if you get institutions working together, particularly if they are collaborating, this allows you to benefit from each of their different ways of thinking and reasoning. The hope being, this wonderful world, they'll all come with their different strengths, pull them together, and we'll end up with much better decision-making than if they don't talk to each other. And the dialogue essentially started off, particularly in human rights theories. So the idea would be that if you've got courts and parliaments talking together, reasoning in different ways about rights, having legislatures being able to respond to court decisions in a constructive way, you would end up with a much better protection of rights. At least that's the theory, and it underpins the way in which the UK protects human rights in the Human Rights Act and how this wonderful ACT protects human rights through your legislation as well. So the idea is they pull together, you get a better protection of rights. What I want to look at is how in recent events in the UK Constitution, there's a very easy narrative we can tell. And the easy narrative we can tell is we've just killed dialogue. Hope you don't mind. It doesn't work. And there's various reasons why recent events seem to suggest that dialogue is not really working. That's partly because if you look at recent events, you can see rights protections are being eroded. You can see institutions are not working together collaboratively. In fact, most of the time in the UK, we spend our time fighting. We just, everyone's just having a go at the other institution and things just don't seem to be working. So what I want to do is take a step back and think about why is this happening? Is this showing that dialogue doesn't work? Or is this showing that we don't really understand how dialogue is meant to work? And particularly, is dialogue suited to some situations and not others? So that's basically what I want to think about. And what I'm hoping to explain to you is that this simplistic picture that dialogue is just about Parliament does its thing, courts do their thing, and somehow we end up with the better protection of rights is precisely, it's just too simplistic. Dialogue is much more complicated than that. And what's going on in the UK at the moment shows that the different element of how inter-institutional interactions can work effectively and also how they don't work very well at all. And it's much more subtle and nuanced than this kind of idea that we'll get from some accounts. So you're going to get first a brief snapshot of what's been going on in the UK, in which you'll think yourself very, very lucky that you weren't there. So as probably I'm sure you are aware, we left Europe. We thought, why not? So we had a referendum on the 23rd of June 2016, and the outcome was not what the political elites thought it was going to be. The vote was to leave, not to remain. And the aftermath of that referendum vote, it's been huge. So we lost two prime ministers on the basis of the referendum. David Cameron, because he supported Remain, and Theresa May because she couldn't get the withdrawal agreement agreed to by Parliament. So she ended up leaving as well. We've ended up with two major decisions of the UK Supreme Court where they sat with, not only they sit with 11 members out of the possible 12, which is unheard of, it's the only time it's happened. They also had wall-to-wall media coverage of the Supreme Court. So sad academics like me were literally stood with a microphone outside the Supreme Court going, so what Lady Hale has just said is the following, and commenting on what's going on. This was how ridiculously big decisions got. I mean, you don't normally know decisions are taking place in court, let alone having literally wall-to-wall news coverage of what's going on, talking about what the barristers were saying and talking about the consequences. So it just put the Constitution right in the spotlight of what was going on. We then had various events in 2019, which it's hard to kind of set out. I'll do my best to give you a snapshot of just how ridiculous things were in our Parliament in 2019. We had the largest ever post-universal suffrage defeat of a government. Okay, voting against Theresa May's withdrawal agreement. The very next day, we had a vote of no confidence in the government, and the government survived. So you have this kind of tension between massive defeat, but actually you still want to be a government, even though this was a massive defeat on a major policy argument. You had examples of backbench MPs being able to get bills pushed through the House of Commons in one day that required the government to do something the government did not want to do. And they did this by creatively interpreting the rules of how Parliament worked. We had various votes to have a general election under the Fixed Term Parliament Act, which they lost. So the government decides, OK, we'll bring in another act to overturn that one in part so we can have an early general election without the consent of the House of Commons with 2/3, which is what the Fixed Term Parliament Act would require to have an early general election. So it was just madness. Things were happening on a daily basis. We then moved away post-Brexit into a new constitutional phase in which the government decided to bring in far more constitutional justifications and modifications. We had an independent review of administrative law because the government thought the courts were taking too much power. We had an independent review of human rights law because they thought the Human Rights Act was restricting their powers too greatly. We've since then had a huge raft of legislation which has altered the constitutional balance in the UK. So we no longer have fixed term parliaments. We now have maximum term parliaments again, with the government being able to decide the time of a general election with very little legal or political oversight. We have changed judicial review. We threatened to get rid of the Human Rights Act and repeal it completely. And recently we brought in everyone's favourite act, the Illegal Migration Act, in which we finally made Australia look nice towards migration policies. This requires the Home Secretary is under a duty to return all people who arrive in the UK illegally. Anyone who arrives in the UK illegally can be detained for up to 28 days without bail. If you want to bring a human rights or asylum claim, you've got to do that from Rwanda. You can't raise it in the UK. You'll be removed to a safe third country. The only safe third country we have a deal with at the moment is Rwanda. You can bring your human rights claim there. So everything has changed radically in the post-Brexit constitution. You might be thinking, what's that got to do with dialogue? What it's showing is partly when you're in this kind of situation of a constant series of constitutional crises, dialogue just breaks down. You're not going to get collaboration. You're not going to get nice interactions. But I think what it's also showing you is how aspects of dialogue can be so easily undermined. So if we go back to how we see democratic dialogue in this kind of simplistic sort of way that I presented at the beginning, it's meant to be an element of a better protection of human rights. Okay? So if we can see signs of human rights protections eroding, then does this mean dialogue isn't working? It's meant to be an element where we've got quality, collaborations, institutions talking to each other in a good way, building on their strengths and helping to correct their different weaknesses. But if they're not working together and they're not collaborating, does this mean that dialogue itself doesn't really work? And the biggest criticism you have of dialogue theories is they're just inherently unstable. You can't have a system in which you've got Parliament and courts kind of understandings of legal constitutionalism, where you think laws should be doing the predominant element of ruling, and political constitutionalisms and Parliament, where you think political principles should be the main kind of form of check. You can't have them working together. They will collapse into either predominant legal constitution or predominantly political constitution, where either Parliament always has the final say or courts always have the final say. And if you look at what's going on in the UK, seems to be that's exactly what you find. Do we have a weakening of human rights protections? Oh, yes. How can we see this? Well, we started off with the Bill of Rights Bill 2022 to 23, which is now disappeared. So this is no longer going to be pushed through. But the whole point of that was to override the current Human Rights Act. So it's going to get rid of the Human Rights Act, reduce the extent to which courts protect rights, and instead give much greater power to the government and Parliament in determining the content of rights and weakening the protection of the courts. Now that's been put on hold, but what we've got instead is a promise that this won't be coming back, but instead we've got specific examples of bills that are designed to stop dialogue. So the main means of getting the interaction in the UK is Section 3 of the Human Rights Act. And this allows courts to interpret laws so far as it is possible to do so in line with human rights. Okay. So what are we doing? We are bringing in legislation that removes Section 3 from that legislation. So the classic example is the Illegal Migration Act, where we're told Section 3 of the Human Rights Act does not apply to this act. So whenever you're interpreting immigration decisions, you don't read the provisions in line with human rights to protect human rights. That's gone. Instead, courts must read all of these provisions so far as it is possible to do so in line with the purpose of the bill, so in line with the purpose of the Illegal Migration Act. What's the purpose of the Illegal Migration Act? To prevent and deter unlawful migration. So every single provision of this Act isn't meant to be read in a way that tries to balance migration policies and human rights, and tries to get an interaction with the court saying, here are some possible breaches of human rights. Do you want to think about how you're balancing rights and migration policies? Instead, that's gone. The courts have to read all of this legislation in line with the aim of preventing unlawful migration. That's reducing the extent to which rights can be protected. Exactly the same thing is happening in the Victims and Prisoners Bill with regard to determinations of life sentence components, when you release life prisoners on compassionate grounds, and how you determine parole. All that will be taken out of human rights control, and instead the bill itself instructs courts as to how it's supposed to balance the rights, telling them that it has to give the greatest possible weight to the importance of reducing harm to the public. So that's more important than rights. So we do have a system of moving away from protecting rights. Do we have a lack of collaboration? Oh, yeah. We don't have elements of decisions working together again. Instead, we have elements of institutions almost in a constant battle. And you can see this in the reaction you're getting of political bodies to court decisions, for example. So the big decision in the UK is Miller 2, which is the prorogation of Parliament case. So this was when the Prime Minister decided to prorogue Westminster for 5 weeks. And the question was this unlawful? Could you have a legal check over how long you suspend the operation of Parliament? And the answer from the Supreme Court was yes, there are legal checks. This prorogation was unlawful because it was too long, a constitutionally sensitive time, and you didn't give us any reason for why you wanted a longer prorogation in this case. Why is this a problem? Because of how the legislature reacted. Yes, it accepted the judgment. Yes, it went along with it and Parliament did come back. But then the first thing you get in the post-Brexit constitution is a whole raft of changes to reduce powers of the court and remove the specific ability of the courts to do what they did in Miller in different situations. So when they decided to move back to maximum term parliaments instead of fixed term parliaments, they brought in the Dissolution and Calling of Parliament Act 2022, which shifts it back to the ability to call a general election at a time when the government wants to, rather than having fixed terms. And that decision is non-justiciable, cannot be questioned by a court, specifically as to the limit or extent of the power. And that's a specific reaction to stop courts doing Miller to the dissolution of Parliament rather than to the prorogation of Parliament. So it's no longer a kind of nice interaction. It's you've moved this far, we don't like it, we are pushing back. You can also see it in the reactions of the governments to its constitutional reforms. So we had independent reviews of the Human Rights Act and independent reviews of administrative law. You then had this huge raft of information, and the government then responded to the independent review by saying, thank you very much for your responses. Although 95% of you think that the Human Rights Act is a good thing and we should keep it, we've decided it isn't and we're going to get rid of it. Well, it doesn't look much like collaboration to me if you go away and have an independent review and the answer is, well, thank you for your view, but we don't agree with you, so we're not even going to listen or take anything on board, and we're just going to go away and do what we want to do. That does not look like you're being collaborative. It looks like you're deliberately trying to push back. It looks like we've moved to a system where Miller 2 is seen by many as, haha, we're moving towards a legal constitution where the courts are able to have a large amount of power and push back against Parliament. Parliament then gets a large majority and says, no, no, you're not. We are in charge. It's all political constitutionalism, and we will just push back again. There doesn't seem to be any kind of element of institutions trying to work together in a collaborative and balanced way to get a better protection of rights. It just looks like we're in a fight and we're just constantly pushing back against each other. So if you wanted evidence of dialogue looks great in theory, but put it on the ground and all it will do is end up collapsing into a series of battles, then the UK's experience through Brexit and establishing a post-Brexit constitution would seem to give great evidence. Dialogue is just not going to work. Why do I want to argue against that? The reason I want to argue against that is because I want you to think about what dialogue actually is and understand why I think dialogue is not just about human rights protections, and it's not just about this element of thinking that, well, as long as courts and Parliament talk to each other and are nice to each other, somehow we'll end up with a better system. I just don't think that's what dialogue is about. Why not? First, I think dialogue is much broader. Dialogue is not just about human rights protections. It can also be about other areas as well. So it can be about how we think about the separation of powers. Do we get institutions interacting with each other to think about what the distribution of power should be between these institutions, particularly in a system like the UK, where there is no locked-in setting out of what the separation of powers should be between these different institutions. I also think that it's not just a system where the value you get from dialogue is human rights get a better protection. I'm not even sure what a better protection is in some circumstances, because much of some would say, isn't it terrible that human rights are being eroded? Others might say, no, we're redressing the balance and putting it in a better place and recognising that perhaps sometimes there were too many rights and that we weren't able to protect the sovereignty of our particular country in certain circumstances. So how do we even assess what a better protection of rights is if you think rights are inherently contestable? I think it can be not just about a better protection of rights, but there are other values that you can get from dialogue theories. I think if they work properly, they can facilitate deliberation and participatory democracy. They can help get a better set of checks and balances. And sometimes they can help you avoid a massive constitutional crisis and find a better way of resolving it rather than pushing everything to an element of sort of all-out warfare between different institutions. So it's not just about human rights, it can promote other values as well, and it can apply to other kinds of interactions. I also don't think it's just about collaborating. It'd be lovely if all our inter-institutional interactions, it's really hard to say that, was all about collaborating. Sometimes there is a need for pushback. It's what I call constitutional counterbalancing, where if you can see one institution's transgressed into your powers, it's legitimate in certain circumstances to push back. And if you go away and take a step back and look at the events in the UK, thinking about it more broadly, I think you get a different picture, because there are some elements where that has been working effectively and some where it hasn't. So there have been some elements of counterbalancing that have facilitated other values and some that have not. So the one example I want to give of when counterbalancing has facilitated values is going back to Miller 2. And the reason I think that worked is because in that case, you had the Supreme Court intervening not to protect its own powers, but to protect the powers of Parliament. The government had decided to prorogue Parliament, shutting down democratic deliberation for a long period of time in a situation where Parliament itself couldn't do anything about it. Once you prorogue, that's it, Parliament's gone. It can't have it. You don't have a debate. You don't have the government standing up saying, I'd like to prorogue Parliament, let's have a debate about it. They just turn up, issue the order, and that's it, you're out. So by intervening, the courts was promoting democracy. Also by intervening, they did so in a way that tried to uphold separation of powers effectively in a way that might facilitate collaboration between the institutions. The government couldn't prorogue without a justification. So you could have had a longer prorogation if you'd backed it up, and the courts could have had a look at, is there a justification here? And they wouldn't have scrutinised that too stringently, but would have arrived an element of collaboration, of reason giving, of thinking through when you can and cannot prorogue in exceptional circumstances, because there was the constitutional crisis going on, and it was a long period of time where Parliament would be moved out of an important decision. I think that is a way of pushing back that helps to facilitate these other values. But if I look at the examples of what's been going on with the new legislation, I think this is a way of pushing back without respecting that. Not just because I think they are restricting rights, but because of the way in which these pieces of legislation have been enacted. They've been pushed through Parliament incredibly quickly, with very little time, with a huge use of what we call placeholder clauses. So this is where the government introduces a bill, doesn't tell you what a provision of the bill is going to be, and then allegedly at committee stage will then give you the clause of debate. In the illegal migration bill, about 82 pages of it appeared at report stage, right at the final stage, with 5 hours of debate, including quite large provisions that undermine human rights protections by bringing in automatic stop and search powers for individuals arriving in small boats. Just if you suspect they might have arrived here unlawfully and might know something about trafficking, you can search them and you can get rid of all their electronic devices, just shoved in a schedule. Very little debate. My concern about that is that that is counterbalancing, that isn't also facilitating those other values. So what is it telling us? Hopefully what it's telling you is dialogue is not just about human rights protections. It's about thinking about how we get good interinstitutional interactions. It doesn't necessarily collapse into legal and political constitutionalism if what you're doing is taking a step back and saying, how are these interactions working? Do we get interactions that are facilitating other values or that aren't? I think it's also telling you that, like most theories, put it in a series of constitutional crises and it's not going to work efficiently and effectively. Of course, it's not going to be fully accurate because the assumptions on which the theory is based just aren't necessarily working. But it can still be used to take a step back and work out when these counterbalancing measures find a way of hopefully appeasing the crisis and coming to a better solution, and when these counterbalancing measures are not doing that and actually escalating the crisis and making it very difficult to resolve. I think the other big lesson is if you have a referendum, think incredibly carefully about your question and think incredibly carefully about how you inform the people voting on a referendum, what it's achieving and where it's going and what its values are, and recognise that a referendum is hugely politically persuasive, even if you don't have any kind of legal responsibility in response to it. So my hope is your upcoming referendum is a much better way than the Brexit referendum was. Thank you.